Hello everyone, this is Vandana Mishra, and today our topic is the examination of witnesses. Through these slides, we are going to know about how the witnesses are examined during the proceedings or the trials. Okay, so first of all, we will know what are evidences. Okay, so evidence is a term which is taken from the Latin term evidence evideria. This Latin term means evidence. Okay, so evidence is basically taken from the evidence evideria, which is a Latin term. Okay, and the very famous jurist Sir Taylor had defined law of evidence as an argument that approves or disapproves of a given fact. So basically, he want to say that evidence is an argument. Evidence is a fact which either approves or disapproves any fact. Okay, so the argument which we present in before court to prove or disprove our fact are known as evidence. Okay, so evidences is very important, as without it argument would become baseless. And of course, evidence we need to add evidences to our cases and facts so that we can make it more strong. Okay, now we will know about how the uh, witnesses are examined in the courtroom. Okay, so first we will see here, that is there is an in evidence act of 1872 in India, which tells us about the evidence, how it is found and how it is used. Okay, so we all deal with the evidences from the evidence act of 1872, which is our which is in our India. Okay, second thing, Indian Evidence Act uh, has 11 chapters and 167 sections. Okay, which came into force from 1 September 1872. Okay, so and the examination of witnesses, the topic of examination of witnesses are discussed in chapter 10 of the Indian Evidence Act. Okay, and there are 31 sections in this chapter which we are going to learn here. Okay, so next slide. So first section is, that is section 135, which tells us about the order of production and examination of witnesses. So here we can read, like, it tells about the order of production and examination of witnesses. This means this section basically tells about the order in which witnesses are produced and examined before the court. Okay, and after that we have a section 136, which tells us about the judge to decide as the admissibility of evidence. Basically, in this section it is told that judge have the discretion to either allow any evidence or to not allow any evidence. Okay, like, if you want to see, like, if any if judge do not want to allow that evidence for any fact, then it is his discretion to allow or not allow. Okay, if he don't want evidence for that fact, then he will not allow. Okay, and if he want, then he will allow the evidence. So section 136 talks about this judge discretion. Okay, now let's go to section 137, which give a definition about the examination in chief, cross examination and re-examination. So basically, examination in chief are what? The examination of witness by the party who calls him shall be called his examination in chief. Okay, so let me give example, like, uh, if we are if we are calling an evidence. Okay, an witness, sorry, if we are calling an witness, then our party will be the examination in chief. Okay, because we are calling that evidence witness. Okay, and second one is cross examination. Cross examination is basically the examination of witness by the adverse party shall be called the cross examination. So cross examination is that the examination of witness by the adverse party. Adverse party means the opposite party. Okay. So the examination by the opposite party is known as the cross examination, and then the re-examination. So re-examination is basically the examination of witness subsequent to cross examination by the party who called him shall be called his re-examination. Like if the same party which has called the witness is examining the party again after the cross examination, this will be called as re examination. Okay, I hope this is clear to everyone. Now we will go to another section. So here is the next section, that is section number 138, which tells about the order of examination. So it basically it tells about the order in which the witnesses are present. Like witness shall be first examined in chief, then it will be cross examined, and then it will be re examined. So this is the basically the order of examination which we get to know in section 138. Okay. Now second thing which section 138 tells is the direction of re-examination. It basically tells that how the re-examination is directed. Okay, like how the re-examination will be directed, how the matters will be referred in the cross-examination by the permission of court, how all the procedure of re-examination happen. It comes under this section. Okay. Now section number 139, which tells about the cross examination of person called to produce a document. This means that a person who is summoned to produce a document will be examined unless he will not be cross examined unless he is a witness. Like if any person is summoned to produce a document only, so he will not be considered as a witness. Okay. And if he will not be considered as a witness, then he would not be cross examined. Okay. Now section 140, it tells about the witness to character. Witness to character may be cross examined and re examined. It basically says that witness to character uh, can be cross examined or re examined. Okay. Now the next slide. Section number 141, which talks about the leading questions. So leading questions are basically any question suggesting the answer which the person putting it wishes or expects to receive is called leading question. So basically leading questions include any questions uh, which whose answer is been expected by the person. Okay. And now section 142, it talks about the when they must be asked. So it talks about the leading question, that when a leading question must be asked, and if objected to by the adverse party, be asked in examination in chief or in re-examination, expect with the permission of court. Okay. Like it talks about the when the leading questions will be asked with the permission of the court. Okay. Now section 143, it says when they must be asked. So it also talks about when the leading questions must be asked in cross examination. Okay. Section 144 talks about the evidence as to matter in writing. Evidence as to matter in writing. It says that it says that witnesses may give oral evidence of statement made by other person about the content of document if such statements are in themselves relevant fact. Like it is saying that if an witness want to speak something or give some oral evidence, then he can give an oral evidence which are also a content of a document. Okay. Now we'll come to section 145. It is like cross examination as to previous statements in writings. It tells about that a witness may be cross examined as a previous statement made by him in writing or reduced in writing. Like if a person have given a statement in writing or in oral way, then he can be cross examined also on the basis of his previous statements. Now the next section is section 146, which talks about the questions lawful in cross examination. It tells that when a question is cross examined, it should be a lawful question, Like we can say, it tells that when a witness is cross examined, he may, in addition to the questions herein before referred to, be asked any question which tend to. So, section 146 is basically what it is saying, like if a question has been asked, then the witness is cross examined in such a manner so that we get to know about we get to test his veracity, to discover who is he and what is his position in life, and to stake his credit by injuring his character. Okay. And the next section is 147. It says that when witnesses to be compelled to answer, it basically tells about when the witnesses are questioned, he is compelled to give the answer to the court. Okay. And now section 148, which says court to decide when questions shall be asked and when witness compelled to answer. So basically, in this it is written like, when it is said that court will have the right to decide what questions will be asked and when the questions will be asked. Okay. And witness will be compelled to answer or not. Okay. Now the section 149, which talks about questions without reasonable grounds. It says that a question cannot be asked without reasonable ground. Okay. The questions which are being asking by the witness should be on reasonable ground basically. Okay. Now section 150, it basically talks about the procedure of court in asking the questions without any reasonable ground. Like the if any question was asked without any reasonable ground, so it may be asked either by the report of any circumstances of the case or by the other authority to which the subject is in exercise. Okay. Now section 151. Section 151 tells about the indecent and scandalous question. It talks about the questions that are not decent and which are it is basically the forbidden by the court to ask any question which is indecent in manner. Okay. Now go to the section number 152. It basically talks about the questions intended to annoy. Okay. So it basically tells the court shall forbid any question which appears to be intended to insult or to annoy. So this section basically gives the court to power, that court can avoid or forbid the questions which are raised to insult or to annoy the witness. Okay. Now section number 153, it talks about the exclusion of evidence to contradict answers to question testing veracity. This says that which evidence are by asked by the which evidence are used to ask the questions by the witnesses. Like if we read it, when a witness has been asked and has answered any question which is relevant to the inquiry only in so far as it tends to shake his credit by injuring his characters, no evidence shall be given to contradict him. Okay. So I hope it's clear. Like it is saying that if a witness is giving any answer which is injuring his character, then no evidence is required for this. Okay. Now section 154 talks about the questions by party to his own witness. Like it says that it's the court discretion basically to allow the party who has called the witness to. So basically this section tells about that if it's court discretion to allow any party to to question his own witness or to not. Okay. Now we'll go to the next section, which is section 155, which talks about the impeaching credit of witness. It basically tells that a witness declaring another witness to be unfact of credit may be, upon his examination in chief, give reasons for his belief, but he may be asked for reason in cross examination. This section tells that if one witness is saying that another witness is false, then he have to give the reasons for his belief, and and his all the facts will be cross examined by the advocates. Okay. Now the section number 156, which tells that questions tending to corroborate evidence of relevant facts admissible. So if we read it, we get to know like when a witness whom it is intended to corroborate gives evidence of any relevant fact, he may be questioned as to any other circumstances which he observed at near or the time of place. So if it is talking about if a witness is present at the place of crime or place of things where it happens, so he has to give the relevant information and relevant evidence regarding this. Okay. Now the section number 157, which tells about the former statements of witness may be proved to corroborate later testimony as to same fact. So in this up, up a witness is cross examined again by his former statement that he has told it correct or not to at the previous time. Okay. Now section number 158, it tells about the what matters may be provided in connection with the proved statement relevant under section 32 or 32 33. So in this, basically evidences are given so that we can prove the facts which are given in the section 32 and section 33. Now the next section is section number 159, which talks about the refreshing memory. So it takes that it says that if a witness want to recall the news, recall the information, then he will get the time to refresh his memory and then to refer the documents. Okay. Now we will go to the section number 160, which talks about the testimony to the facts stated in document mentioned under section 159. So basically, this section tells that uh, the facts which are stated in the documents will be tested in the trials also. Okay. Now the section 161 tells right of adverse party as to writing used to refresh memory. This section basically tells that adverse party have also right to refresh the witness memory by writing and by any process they want. Okay. Now the section 162, it basically talks about the production of documents and translation of documents. It basically talks about the how the documents are produced, and if any documents is not understood by the court or by the bench, then how it will be translated. Okay. So that it became a proper and valid evidence. Now the section 163, which takes about a giving as evidence of document called for and produce on notice. Like if an evidence is given, then it can be if a document is given, it can be used as a evidence. Okay. And now section 164, it also says that the same thing, but it says that the document will be refused to be on notice if it is not been used as evidence. Now section 165, it gives the judge it gives judge power to put questions or to order production. Like the judge can question that from where you get the evidences. This section gives the right to the judge. Okay. Now section 166, it tells about the power of jury to put questions. So basically these are all the end of the sections which comes under the examination of witnesses, and this is the process by which witnesses are examined. And I hope it's clear to everyone, guys. So like, share and subscribe to the Law Minds. Thank you so much.